Okay, thank you very much. So as we said, right, international law has become one of the main tools to isolate, demonize, hurt the state of Israel, and by extension Jews. So this works in two ways. We have the use of international law rhetoric in the public discourse, the accusations of genocide and apartheid, war crimes, and the point, or one of the points of the genocide accusation is to legitimize any discrimination against Jews. So when a Jewish speaker is excluded, is disinvited, then the response is, well, they were pro-genocide. You wouldn't platform a Nazi. It also justifies, right, when synagogues or Jewish institutions are attacked, then it's shrugged off. What does that compare with the genocide that's happening in Gaza? So that's one track, the public discourse. And the other one is the actual use of the legal institutions to prosecute, to sanction, to harm Israelis and Jewish institutions, whether it be through the international courts, ICC, ICJ, or through domestic courts using international law. And all of this rests on a vast academic ecosystem of international law writing that adopts an anti-Israel orthodoxy, while at the same time excluding pro-Israel voices. So Richard Delgado was a professor, a scholar of civil rights law in the 1980s. He wrote a well-cited article called "The Imperial Scholar," and he talks about the tendency of the leading, largely male, largely white scholars to cite their own largely male, largely white colleagues to the exclusion of minority groups who are most affected by issues of racism. And beyond the effect that this has on these scholars themselves being excluded from the conversation, but this leads to a distorted view of what the law actually is. And the people most affected by racism, by discrimination, aren't part of the conversation. And this distorted view then leaks out from the legal academy and goes into society. So first of all, this is what is taught. The professors teach the students. This is the law that is in the public discourse, that's sent to the policymakers, that judges rule on. And so you have the same phenomenon that is happening in the International Law Academy. So we're going to talk here. I mean, one of the problems that the exclusion or this closed circle has is that people with like-minded views, here then only like-minded views, they're obviously radicalized. It's a self-perpetuating cycle in that students with minority views, so Jewish students, pro-Israel students, obviously do not share are hesitant to share their opinions in class. They don't have other professors who share these views. They have then less opportunity to continue into academia, and then it's a vast circle of intellectual gatekeeping, the same ideas being repeated over and over. So I'll just give an example of a highly influential article that I think, on one hand, is very extreme, but I think it captures the view of what Israel and what Zionism is in the legal academy. So in May 2024, Rabia Igbaria, a Palestinian PhD student, published an article in the Columbia Law Review. First, he had a shorter version in a Harvard Law Review. And it's interesting to note that the article was actually kept secret from the majority of the student editors. They didn't go through the normal editorial process. Anyways, it's a highly influential article. It has about 100 citations. It's part of the curriculum for many law courses. It's cited in various activist reports. And so what it argues is titled "Towards Nakba as a Legal Concept." So its argument is that Israel is not only genocide, and not only apartheid, and not only ethnic cleansing, it's all of this and more. And the legal field doesn't even have the proper terminology to describe the evil of Israel, and we need to adopt Nakba as a legal concept incorporating all of these terrible crimes that Israel is committing. Israel's very existence is posited as an ongoing Nakba, and you see this term being used over and over. And so just various arguments, or various claims that he makes, right? We don't have the language to describe Israel's evil. He essentializes Zionism. Just as Nazi ideology produced the Holocaust and Afrikaner nationalism generated apartheid, Zionism similarly birthed the Nakba. You have Holocaust inversion. He says that the Nakba reminds us that a victim group can become the victimizers. So the Jews who were victims of the Nazis today are the new Nazis. And he has Israel as the symbol of evil. For the wretched of the earth, Palestine is a mirror in which to behold their own reflection as they struggle for full liberation from the shackles of colonialism. So this is an example of the bon ton in the journals. You have international law blogs that their advantage over journals is that they're peer reviewed, but they come out very fast. They give the first treatment of various contemporary events, and they have a lot of influence. They're read by practitioners, they're read by judges, they're read by the media. So Opinio Juris, John mentioned Opinio Juris is one of the most influential international law blogs. On October 10th, 2023, they posted an interview with two Palestinian scholars, Mohsen Al-Attar and Noura Erakat, and in an addendum to the interview, they see October 7th as quite favorable. They say that decolonization is always a violent phenomenon, for the colonizer does not give up their loot easily. The article on Opinio Juris links to another article, which again is very in favor of October 7th. It says that international support for Israel is a result of Holocaust guilt. Various articles that they posted. This isn't the original title of the article. The original title of the article was "Israel has no right to self-defense." Another article that came up was saying that Zionism needs to be recognized as an international crime on the level of Nazism. I'll just point out, I don't have this here, but I have this in my Substack, The Jerusalem Jurist. Opinio Juris and other blogs have been platforming actual Iranian regime propagandists, international law professors in Iran, unironically writing about the place of international law in Iran's criminal justice system, who teach actually at universities that are deeply tied with the regime, which actually spy on their students, give information to the Secret Service to have dissident students arrested, tortured, and then murdered. But anyways, they platform them, but not Israeli Jews. And the converse side to the adoption of these extreme anti-Israel views is the rejection of even moderate pro-Israel views. So in January 2024, as Israel was operating in the hospitals in Gaza, Anne Hertzberg, who's the legal advisor for NGO Monitor, she wrote an article setting out the international law implications of operating in hospitals. It was originally accepted for publication on Opinio Juris, and then several hours before it was set to be published, she got a list of dozens of demands for revisions, and it was clear that the demands for revisions were based on content and not based on a professional problems. They took opprobrium to the idea that Hamas was actually operating in the hospitals, and eventually it was rejected. The article is on Fathom Journal. You can judge for yourselves the quality of the journal. I had a run-in with this journal. Alonso Gourmendi is an editor of the journal. He wrote an article arguing that Israel has absolutely no rights to Judea, Samaria, East Jerusalem. I wrote an article responding to that, and the article was accepted, but only for the purpose of debunking it. So the article was actually held for several weeks, not published, until Gourmendi could write a response, because God forbid somebody should just read my article alone and then be convinced. And this policy is not necessarily unique to Opinio Juris. Another blog, Volkerrechts blog, is a German international law blog. Was told explicitly that they would not publish any piece that argues that Israel has any legitimacy in East Jerusalem. First of all, obviously under Israeli law, all of Jerusalem is part of Israel. Israel's civil law applies there. This policy would exclude any, let's say, even centrist Israeli writer. And of course, in the ICJ decision advisory opinion, which is non-binding, that they discuss, the minority opinion by the Ugandan judge Julia Sebutinde says quite clearly, actually, that Israel has a right to Judea, Samaria, Gaza, and East Jerusalem. So they wouldn't publish an article by an ICJ judge. And obviously, you have very many distinguished jurists over the years who have written along these lines. It's a minority position, but they say we will not accept this. You have also the positing or the making of any pro-Israel writer as something that is so controversial. They are far right. They are racist, and they're too controversial to publish. So we have this in the blogs. And going back to the journals, in December 2024, the Leiden Journal of International Law, which is a very influential, well-cited journal, it published an article by 3 Israeli scholars looking at various models of post-war development in Gaza, and they discuss several scenarios without promoting a single scenario. So it's just an objective analysis. And one of the scenarios that they talk about is the possibility of Israel maintaining control over Gaza and developing its gas field. And this created what in technical terms could be called a Twitter shitstorm. That there were many comments from law professors, from UN special rapporteurs, that they can't even bring themselves to read this. How could the journal justify Israeli policies? Eventually, the journal, instead of standing for academic freedom, pulled the article and then eventually reissued it with a disclaimer saying that this article does not represent the views and the policies, the opinions of the journal, as if to say that Israeli writers, just even objectively discussing different scenarios, are so controversial that you need a trigger warning to read them. So we have the blogs, we have the journals, we have international conferences. I'll just give one story. My colleague Eugene Kontorovich is a professor of international law at George Mason University. He's widely published. In 2018, the Asser Institute in The Hague published that it was holding a conference about economic dealings in occupied territories, something that he's published on before, and there was a call for papers. His call for papers was accepted. He was invited to the conference. A few weeks after his proposal was accepted, he got a message from the organizers of the conference that there was an official protest from other participants in the conference that his views were beyond the pale and he should not be accepted at all in the conference. The compromise that they suggested was that their names not appear on any official publications along with him, that the conference should not be shared on social media, not to legitimize his very presence, and they demanded the canceling of the dinner, the social dinner at the conference, so they wouldn't have to break bread with him. And he suggested, okay, if they have problems, I'll make my lecture shorter. We'll have a longer question and answer period. Obviously, they refused that. They stormed out when he spoke. And okay, he's a tenured professor. He's written briefly. This isn't going to harm his career. But obviously, examples like this, right, will deter younger, less experienced scholars. And I have a paper on this. I have many examples of papers just being refused because they mention sexual crimes that happened on October 7th. Just taking umbrage of description of Hamas as terrorist organizations. And so just to conclude, Israel and Zionism have a very intimate relationship with international law. At the first Zionist Congress in 1897 in Basel, the Zionist movement adopted as its official program the goal to establish in Eretz Israel a home for the Jewish people secured under public law. And now you have a whole establishment, industry of this sort of intellectual incest of the exclusion of Jewish voices and the constant citation of the same anti-Israel voices over and over and over again until it becomes right orthodoxy, and that's how international law becomes a tool of discrimination against Jews and essentially exclusion from the discourse and isolation. So just to say, I'm doing my little part to fix this. I have a Substack, The Jerusalem Jurist, which deals with a lot of these international law issues that things often cannot be published in the mainstream blogs. And otherwise, the situation is bad. Thank you.